Okay, I think we can get going. Well, welcome everyone to our Coffee and Conversation. My name is Cecile Holt. I'm an advisor with Ardern Bridge Advisors. And I have the pleasure today to welcome our guest, Jennifer Schiffer from Bean Kinney and Corman. She is an estate attorney and has been a wonderful resource for us and our clients. So thank you again, everyone, for joining us. January is typically a month where we like to focus on estate planning with our clients. And typically, most people don't really like to talk about this. But I think in the COVID era, I don't know if you've experienced this too, Jennifer, but it's like we're forced to address those things that we don't want to talk about. So if you don't mind, I thought I would ask you a few questions that arise from our conversations with clients. Before I get started though, I'd just like to point out that today our goal is to really drill down on some issues. We have done an overview of estate planning basics in a previous video that's posted on our website with Adam Abramowitz. So if you are interested at all about the basics, please go to our website, view it. But today we're going to be a little bit more specific. So just as housekeeping, I'm going to be asking a few prepared questions that we got from clients to Jennifer, but please feel free to submit some questions in the Q&A. We'll try to address some at the end. I'm not sure how much time we will have, but feel free to submit them. Either we will address them on air, or if we don't have time to, then we'll make sure to follow up with you after the webinar is over. So Jennifer, if you don't mind, let's get started.
Absolutely. Sounds great.
Yeah. So let's say I've actually done the right thing. I gathered all my strength and actually met with an estate attorney, and I faced all those tough conversations and decisions, and I have documents on hand. And for whatever reason, my executor, or, if I'm married, maybe I chose my husband, all of a sudden is not capable of serving as my executor anymore, or my power of attorney. What do I do at this point?
So that's definitely a good question, particularly in the age of COVID. I'm getting asked that a lot, unfortunately, because people are having people pass away or become incapacitated, or just realize, gosh, I have the wrong person named. So, every 5 years, or in the event of a major life circumstance change, we recommend looking back at your documents and potentially updating them. So, what looking back at your documents means is, let's say you have your spouse named as your executor and your spouse is no longer capable of acting. So the question is, do you have a backup named? If you have a backup, that's fine. And assuming they are capable of acting in that role, then you don't necessarily have to update your documents just for that purpose. You may want to simply to clarify things, or you might have been leaving items or money to whoever you had named originally. But as long as you have a backup who's capable of acting, that's fine, and you don't have to necessarily update your will. With regard to your power of attorney, it's kind of the same thing, but your powers of attorney particularly, we recommend updating fairly regularly, or re-signing or doing something like that, because they go stale and financial institutions have a hard time accepting them if it's really old and the original agent is deceased or incapable of acting. In addition, powers of attorney, one of the problems with it is the person you've named as agent cannot name a backup for you if they're acting in that role. And that's a question I get asked a lot is, okay, I'm incapacitated, my agent's acting, and they realize they've been diagnosed with cancer or something. Can they then name a backup for me? The answer is no, unless your power of attorney explicitly says that. So that's why you probably want to look back, make sure you potentially update it so you have a backup, particularly if your original agent isn't able to act.
Mm-hmm. Something that people ask, I don't necessarily have anybody I trust locally. Is it okay to name someone that's not in your state, or is it best to go for a location?
So no, it can, particularly power of attorney and executor, can be people who are not local. I definitely recommend naming someone who is a U.S. citizen, or at least a U.S. green card holder, because if you have a foreign national trying to serve in those roles, it will be very complicated. But outside of that, no, if you know your brother's in Michigan and your sister's in California, and those are the only people you have to name, go ahead and name them. It's not important to have someone super local because, in this day and age of technology, and particularly now with COVID, with Zoom and all of that, people can get around most every problem when somebody's not local pretty easily.
Okay, so better to go with someone that you trust rather than someone that's just local.
Absolutely.
Okay. And what if, for example, I am the person named, I'm an executor over parent, or I'm a power of attorney? How, that's an overwhelming task. How can I prepare for this?
Yes, so that's a question I'm getting asked a lot these days. The first thing I would say is sit down with your parents and make sure you understand, what assets they have. Because just because they have a will or a power of attorney doesn't mean they've organized anything else. One of your tasks, particularly as executor, is going to be to gather the assets of your parents and then to distribute them out pursuant to your will or pursuant to their will. So you need to know what those assets are. What I like to say to people is even if you're not willing to give your agent or your executor all of your information for security reasons, for whatever reason, try and create at least a breadcrumb trail so you know how to go back and find your way to the bigger account. For example, okay, say your parents might have, say mom and dad, what banks do you have accounts with? So I at least can know and go and contact them. And where are your original documents for your will and power of attorney stored? Who do I need to contact for your taxes? Who do I need to contact for your financial information?
Yeah.
Things like that. Just start sort of poking around. Again, some people, and particularly clients of a certain age, which might be the parents that people are handling these estates for, aren't willing to be forthright with the information. So you just want to know where it is. Even one of my clients said, well, I'm not telling anyone, but I'm just going to tell them it is in the fourth ceiling tile from the left in my den. I said, okay, and that's where she kept all of her originals and all of her bank statements and everything. But that's fine as long as they know
Right.
that piece of information somehow, again, so that there's breadcrumbs so you can find it. Because the worst case scenario is when I've ended up having to hire a private investigator.
Oh my.
Go around and have to find assets of these people. Otherwise, it ends up with Virginia unclaimed property or something like that, which is a total nightmare to deal with.
Right. And how much of, has the digital world made any changes to this? You kind of have to make sure you have passwords stored somewhere for your executor, or?
So that's a good question. I mean, technically, your executor and your power of attorney are supposed to go through the bank or the financial institution to gain access.
Can't log in as you, right? Theoretically.
Right. Now, where that gets tricky, my practical advice and my legal advice differ. When you're executor, you definitely want to leave everything and you don't want to log in and do anything like that. As power of attorney, if you're acting and you need to pay someone's bills, it kind of might make sense if you know their password to log in. So there are lots and lots of, password encryption sites you can use to hold your stuff. I have one client who told me she just keeps a little black address book in the top drawer of her desk and updates her passwords there so someone could come and find it if they need it. Right? I mean, security, that freaked me out, but
probably not the best, but
so it really depends. Ideally, someone would know your password and be able to do that, but legally speaking, they need to go the roundabout way to go to the bank to get everything taken care of and then log in as you.
Okay. Another question that we get, especially with, kids going, colleges being open and children going off to school and the stress associated with it, it's a question we get more than ever is, my child is 18 now, they're of age, so to speak. What are my rights and what if something happened to them? Should I have documents for my children?
That is a good question. And I mean, the short answer is yes, you should, because they're adults now. I mean, technically speaking, you're their next of kin, so you would get contacted to make the decisions for them. But a lot of universities are recommending that children have powers of attorney and have advance directives completed that they've signed authorizing one of their parents to make decisions for them. And particularly in the advanced medical directive, 18-year-olds have opinions too, and they may have something totally different than their parents. They may say, I want to be kept as alive as long as possible, or totally the reverse of it. But so it's definitely time to sit down. I know it's a hard conversation to have, but I know a bunch of schools are recommending to their students that they get these documents, and they're even offering portals for people to upload them on the university's website so that the university has a copy of it too, in case they need to be contacting someone, if they're admitted to a hospital or something like that.
Does it add a level of complexity that children may go out of state, and is there different laws in different states with regards to medical directives?
So that's a good question. I mean, the short answer is yes, there is some level of complexity. For example, some states permit assisted suicide. As horrible as that sound, morbid as that sounds. So, for example, that's not permissible in Maryland and Virginia, at least currently. So we don't include something like that in our advanced medical directives. If you were to go to Washington State or Oregon, I believe they permit them. So you might need a document there. But generally speaking, powers of attorney, advanced directives are governed by the state you're a resident of. And when you're a college student, you're still a resident of Virginia, and they would just have to apply Virginia law to you wherever you may be.
Got it. That's a good reminder. Ooh, what a fun topic.
Right. No, it's scary. I mean, but I had a lot of people, particularly in August, coming to me with that question because they were scared sending their kids off to college with COVID. What happens if they end up in the hospital and I'm not there? How do they reach me? I mean, hopefully they have contact information or cell phones or something like that. But having the actual written document is a good sort of cleanup item to do.
Mm-hmm. Well, as long as we're on this morbid topic, thanks everybody on the call for hanging in there. So what if I'm terminally ill? What's the best way for me to share my end of life wishes with my agent, the ones I love? Like, how do I make sure that my wishes are implemented?
Sure. So, an advanced medical directive or healthcare power of attorney or living will, any of those that it goes by, is the best way, because then you have written instructions to someone about your wishes. Now, in Virginia, as Virginia residents, one of the nice things is through the Virginia Department of Health website, you can actually upload your advanced medical directive, and allegedly it'll be pulled up with your electronic medical records if you're ever admitted to a hospital in Virginia. Now, I say allegedly, no one's ever told me if it works or not, but it's a free service.
And I'm smiling because they send you a little card, and when you lose your card, it also defeats the purpose. So when you do that, just make sure you keep that little card you get in the mail.
So, I mean, because one of the things is, okay, great, you've written that document, but that document, again, is sitting in, let's say, the fourth ceiling tile in your den. Well, how does someone know to make a quick decision what you want? So I would say, make sure you have that document in place. You potentially email it to whoever's going to be making decisions for you. But I would also say, tell people what you want done, because sometimes, particularly on the medical front, those decisions are having to be made in real time, really quickly, without ever going back and looking at one of those documents. So it's a hard conversation to have, but it's a necessary conversation so that the people you love and are making those decisions know. And the other side of that whole coin is, if you've appointed someone and you tell them what your wishes are and they say, ooh, I'm not going to be able to actually implement that, well, then you probably need to go back and redo your document to put someone in place who will be capable of making those decisions for you.
And back to your earlier point, if different states have different laws and the laws do change, it's probably something that you want to periodically review. Again, not to be morbid, but if you wanted to assisted quote unquote end of life, but it's not offered in Virginia, then that might be something that you may want to monitor.
Absolutely. And I mean, I should say it is before the Virginia General Assembly right now. We have no idea what way it's going to go. But if it gets passed, our form advanced directive and frankly the Virginia form that you can just find on the Virginia Department of Health's website likely is going to change and get updated to add that provision in there.
Mm-hmm. Yeah, I can't imagine being the agent having to pull the trigger on that.
No, I mean, it's a horrible, again, that's why you need to make sure whoever
Have
you've
those
named is
tough
agent.
conversations, not only do the work and meet with you, but actually making sure that the people that you name are willing to act and follow your wishes.
Right.
Good. Well, I'm gonna switch gear for a little bit, because it's getting a little heavy here. As part of what we do as financial planners, we assist a lot of people in transition, and sometimes some of the people we assist in transition are going through a divorce. So, we've been talking about making sure that you choose people to, carry out of your wishes, etc. But what if, I'm still married, but I'm going through a divorce, and my soon-to-be ex-husband or ex-wife was named as my power of attorney, executor, etc. What happens? Do they still have rights? Do I need to make changes immediately? How do I best protect myself?
Sure. So likely the short answer is yes, you want to update your documents immediately and not to sort of reference
Not wait until the divorce is final.
Right. Not to reference a pop culture thing, but some of you may remember Lamar Odom and Khloe Kardashian. When he was in a coma in Nevada, they were separated but not divorced. So they were still married. And she was actually the one making all of his medical decisions for him. Now, that was fine. And she did the right thing and, is forever grateful to her. But some people in that situation wouldn't do the right thing. And, particularly if it's a contentious divorce or something else, you may not want them making those decisions for you. So it's definitely, if you're going through a separation, you definitely want to look at your estate planning documents or potentially create estate planning documents to name someone other than your spouse or your separated spouse to make decisions for you. Now, legally, while you're still married, your spouse has what's known as the spousal elective share claim in Virginia. So potentially you can't disinherit your spouse. If you did, your spouse could come and claim a certain portion of the estate as theirs, depending on the time of marriage, the length of marriage, if you had children during the marriage, things like that. But again, you definitely want to update your documents while you're separated, because if, particularly let's take COVID, if you go into a coma and someone's making decisions for you, that person you've been separated from for 6 months, do you want them making all your medical decisions? Do you want them going in and making your financial transactions to pay your bills for you? So it's definitely the right time to look at your documents and update them. And then potentially after you are divorced and have a marital settlement agreement or a property settlement agreement, you may need to go back in time and update those documents again to reference those documents or make sure they incorporate everything with each other.
Makes sense. I would really, if anybody would like to step in from our listeners to ask a question, please feel free to do so. I'm great on time, so you can type in a question in the Q&A, and I'm sure Jennifer would be happy to answer it. So feel free to submit your questions. So in speaking of transition, moving away from a divorce for a second, but transitions, we do have a lot of clients moving out of state and or thinking, I'm going to retire in 3 to 5 years and I'm probably going to move out of state. And it's always like, I need to update my documents, but is it really worth updating now when I'm going to be moving out of state in a few years? Like, what's your typical recommendation?
So, my recommendation is it's probably worth it to update it now because we recommend every 5 years or in the event of a major life circumstance change, updating your documents. Of course, if you move out of state, we recommend you consult with a local estate planning attorney wherever you might be going. But for the most part, what we've found and heard from people is your estate planning documents are still valid. They may require a few tweaks or a few things like that, but you definitely want to get them done when you have changes, because if God forbid you step off the curb and get hit by a bus, you want it to say the right thing now.
Mm-hmm.
And I see one of
Don't
our
wait.
right. I was gonna say I see one of our questions that came in the Q&A is, do estate plans need updated when I move? So the short answer is maybe. A lot of times, so I get tasked often with reviewing people's documents from other states when they're moving into the DC area. And I would say sometimes, if you're coming here from California and your documents are 10 years old, there's enough changes that you probably want to update them. If you're coming here from, West Virginia, and they're not significantly old and you haven't had major life circumstance changes, then you probably don't need to. But that's where we really recommend consulting with a local estate planning attorney who can give you the answers that you need.
In your experience, when people move into Virginia, for example, and they have a trust from North Carolina, would you do just an amendment, or do you typically just do an overall of the documents? What can people expect?
So likely it would just be an amendment to it. Again, it's really going to depend. If the only change is the situs of the trust, then it's a simple amendment.
Pretty simple.
If you're also changing, who your trustee is, what distributions go to whom, then we're probably talking about just amending and restating the whole trust, because there's a significant enough changes to warrant doing a whole new one.
Right. Let's see. So we're having a few questions coming in, and one is, I think all of this will be kind of interconnected, but one is about whether to have a joint trust or two trusts when you're married. And I will caveat that with saying we have another question saying, should we expect to make any changes with, upcoming potential changes to the estate tax law? So I think we can probably kind of combine those two.
Yeah, absolutely. So I would definitely say you want two trusts. I do not like joint trusts. I highly discourage them, and it kills me every time I see one come across my desk, because it just complicates things on the back end for the person. For example, right now I can tell you a client who has a joint trust with her spouse who is deceased, and her child is now disabled. Well, the joint trust does not allow her to make any revisions to that joint trust that they did, because it became irrevocable when her deceased spouse died. And so she's like, well, what do? I have a disabled child. They can't inherit their asset in this trust, how it's written. So we're kind of in a little bit of a limbo.
Yeah, kind of an unintended consequence that.
Right. And so
intention was to simplify, but ended up complicating things.
Absolutely. And one of the reasons they did this joint trust, it is dated from 2000, and the federal estate tax limit back then was $1 million. It is now 11.4 million. In the new administration, yes, we anticipate that potentially coming down, but that doesn't change my answer about the joint trust or individual trust. The federal estate tax limit is portable, meaning you inherit your spouses. I don't anticipate them changing that law. It's been that way for as long as I can remember. And people did the joint trust for the reason that they thought it wasn't going to be portable, meaning you inherited your spouse. So it really doesn't matter related to the joint trust on that.
Got it.
And I see a question, how do you set up a trust for your adult child? So, going with the question, I have a bunch of clients right now who are setting up trusts for their adult children, and it depends based on what the needs are for the child. But your child has no legal right essentially to inherit your assets. So you can put all sorts of different strings and things on them. Just like a parent may say the trust can't pay out until the child reaches 25. Even if your child already is 25, you can put into place a trust that says they can't inherit your assets until they're 50. It can say whatever you want. And again, they have no legal right to it. Now, if your child is disabled, you would absolutely create a trust. It would just be a special needs trust with a few different things in there.
Right. We have a few more questions coming in. One is, if I have a home in joint names with rights of survivorship and I don't have a trust, Is there any other way to keep the house out of probate besides a trust?
So yes, there is, at least in Virginia, and I believe 14 other states have what are known as transfer on death deeds. That is just like a payable on death or transferable on death that you put on an account. It is a revocable transfer on death document that's recorded in the land records that says upon the latter of the two of you to die, where your home goes. I should also say, in addition, in Virginia, if your only asset at your death is a piece of real estate, you're actually not going to go through probate. There's a simple real estate affidavit that gets used and gets filed with the death certificate and automatically transfers the asset to your heirs through the real estate affidavit without going through the probate process. So it's actually, there are a couple, excuse me, different ways in Virginia that you can deal with that problem.
Great.
I see another question that says, someone recommended having our annuities by putting our charities to receive a percentage versus having the executor give them a portion of the funds from the will. Is this a good practice? I'm not sure I totally understand the question. I mean, you can create, first of all, a charitable trust so that you're taking the deductions today. You certainly could have the charities as the designated beneficiaries on your annuities, but I think I would need to know more. And Cecile probably would need to know more too, because it's a little bit of a financial advisor thing for an attorney thing and an accountant thing to really delve down into that question.
Right. I think there's probably more. And as a side note for anybody listening today, if you have a very specific question, feel free to reach out to us offline, and if needed, we're more than happy to connect you with Jennifer. So we often joke that the favorite, whenever we have an attorney, their favorite thing to say is it depends, which to your credit, Jennifer, you don't do, but I understand that you can't give advice.
Yes, absolutely. And I see, so someone followed up on the house question. So in terms of DIY versus, having an attorney do it, again, I'm going to say that it depends. I would rather have documents than have no documents. And this applies to all of your estate planning. For example, as I was mentioning with the advanced medical directive, there is a form on the Virginia Department of Health website. It is not very good, but it is a form and does get something onto paper. So again, you can try it yourself. It's just a matter of, is it done correctly? Does it actually say what you want it to, and does it get it done? And I just heard from someone the other day who was actually telling me the cost of one of those online things where they found it. And I was like, that's the same as our cost. So I have no idea why I would use the online thing if it's the same cost. So I would say explore your options before you use one of the online services, because it may not actually be that much more expensive. And I've seen, I get asked to read lots and lots of documents from people moving into this area. And people are always blown away by the mistakes that are in their documents that they didn't even realize were in their documents when they use that online service. So I would just say, be super careful if you're doing it. But again,
you just don't know what you don't know. It's hard. So
somebody asked, what about an out-of-state trustee? Yep, trustee, power of attorney, executor, all fine to be from out of the state. I mean, if you're debating between someone in Virginia and out of Virginia, my preference is someone in Virginia. But if you have no one in Virginia, then absolutely name someone out of state who you trust, because you'd rather have that person than have no one.
And earlier, a lot of, it sounds like some of our listeners are in Maryland too. You were mentioning Virginia is pretty accommodative with some aspects of not having to go through probate, but what about Maryland?
So it's a good question. And yes, I practice Maryland, Virginia, and DC. Maryland does not have that transfer on death deed that I was just talking about. Maryland also does not have the real estate affidavit that I was talking about, but Maryland does have, actually much better laws related to going from a will into a trust. So my biggest pet peeve that I would say is people create a will and create a revocable trust. Well, they don't do anything to actually put their assets into the trust. So in Virginia, if that happens, you have to go through probate to get the assets from the person into the will and then into the trust. In Maryland, we don't have to do that. We actually can bypass that pour over will and get them straight into the trust. So each state has differences, and that applies not only Maryland, Virginia, DC, but that applies all over the country, which is why I say talk to a local estate planning attorney who can better guide you on those questions. And I see someone ask a question about out-of-state property in California. Is there a place for LLCs in our estate planning? Yes, absolutely. Any LLC you own, you want owned by that trust, or potentially have a transfer on death assignment of your LLC interest into the trust. Because if you don't, then that LLC interest, if you're a Virginia resident, has to go through probate, potentially probate even in California and in Virginia, to end up in your trust, which has totally defeated your purpose of creating that trust in the first place.
Makes sense. Let's see, any other questions coming in? Any other questions that you think you've been asking, you've been answering a lot recently? I mean, going back to, I know it's really on top of mind, the potential changes in estate taxes. I mean, I know you don't have a crystal ball, but if you had to guess any change, let's just say, just as a hypothetical, if the estate, if the exemption went back down to 1 million, for example, what would be your best advice for people? Not that we anticipate it, but I'm just saying, like, if it went back to where it was, and we didn't have that $11 million exemption anymore, what steps would people need to take?
Start gifting. I mean, so gifting is a big tool of estate planning. If your assets are at all, up at the 10 million range, I would start talking to an attorney, start talking to a financial advisor, start talking to an accountant, so that you can get your estate planning in order. Because one of the best things you can do is gifting. And what I mean by that is, if you gift your assets today with the federal estate tax limit as high as it is, you get the benefit of using that full estate tax today, versus people, in 2000, where it was only $1 million, only got to gift $1 million without getting hit with that. And one of the things I should say is, sort of going deeper into estate planning, gift tax is one of the great misnomers that's out there. You do not owe a tax when you gift. All the gift tax limit does is, if you're gifting more than $15,000 per year per person, you simply have to file a gift tax return. That then decreases your overall federal estate tax threshold, but it does nothing other than that. So if you never hit that 11.4 million, no one's paying a tax for you. So that's why I say gifting is absolutely your best tool to deal with this now, and to see what you can do to get some of your assets out of your name and into other people's names before that tax law change happens.
Okay. And again, we have no idea what might happen, but what we have a new question coming in, and it is, what is the federal limit and in Maryland before you start paying estate taxes, and how does the portal work with a deceased spouse?
So that's a really good question. The federal limit, it currently is 11.4 million. The Maryland limit, I believe, currently is 5.6 million. However, the year your spouse died in is whatever limit they had. In order to make it portable and inherit your spouse's, an estate tax return needed to be filed in Maryland and federally, I believe, within 9 months of your spouse's death, in order to preserve their estate tax limit. So I don't know what year your spouse died in, but if it was 2020, you need to act fairly quickly. If it was 2019, I would say talk to an accountant, talk to me, talk to some other attorney, talk to a financial advisor very quickly, because maybe we can do something for you. If it was pre-2019, that may just be gone. again, talk to someone, but it's one of those you need to act pretty quickly to preserve it.
And that's a good reminder too, that each state will have their own estate tax limit, that there's a federal limit that's very high right now, but some states have much lower limits. So
Correct.
it's not an issue, but some states can be pretty,
And so Virginia doesn't have an estate tax. DC's went up to the federal level and came back down to 5 million. And Maryland's has been hovering around that 5 million for a while. Maryland also has what's known as an inheritance tax, which very few states have. But the inheritance tax applies if you're passing assets outside of your lineal family. So if you're going to someone other than your children or your parents or your spouse, you get hit with the inheritance tax.
Someone is asking about the portal. I think it's probably referring to the medical directives portal. Do you mind going back over that really quickly?
Sure. And there's a link again on the Virginia Department of Health website where you can upload the advanced medical directive. So it would pull up with your electronic medical records in Virginia. And if you ever want to update your documents, not a problem to upload it into there. It just is linked to your driver's license number and your phone number and name. So it's a really easy and great tool to use and have out there so that, it's somewhere other than just, in the fourth ceiling tile on your house. So it's portable is the word. Portable with a deceased spouse. The federal estate tax limit and the Maryland estate tax are portable, meaning you can your spouse can inherit yours and you can inherit your spouse's. But again, to preserve that portability, a estate tax return needs to be filed in Maryland and federally to preserve that portability. So while we say the federal estate tax limit is 11.4 million, if you inherit your spouse's, it's ported over to you essentially because you filed that federal estate tax return. And so it becomes 22.8. Now, everybody doesn't need to file an estate tax return. If your assets are down at $2 million, there's no need to preserve this federal estate tax limit. But if your assets, are again at that $10 million level, you may want to think about preserving that and talk to someone and figure out whether it's worth the cost and hassle of going through and making sure that tax return is filed.
Makes sense. Thanks for clarifying. Good. So it looks like we're hitting the 40-minute mark, and people's coffees might start getting cold. But again, if you have any more questions coming up from this conversation, feel free to send them our way, and then we're more than happy to connect you with Jennifer. She's a wealth of information, as you've probably experienced today. And really, thank you for joining us today. Feel free to reach out. We're here to help. We have one last question, and then we'll go on our way. Where would you recommend getting information on how to set up a trust? I would say contact Jennifer.
Right. I was going to say an attorney, accountant, financial advisor, any of us. Google is fine, but it's kind of, we joke, Dr. Google, attorney Google. You're going to get lots of information that's totally going to overwhelm you, and some of it'll be accurate and some of it won't. But just like if you Google, a hangnail and you come up with amputate your finger, legally, you're probably going to come up with some crazy hits like that too.
Right.
So again, talk to an attorney, talk to an accountant, talk to a financial advisor. We're the ones who can point you in the right directions. And if you don't necessarily want to hire one of us, we can send you in the right direction to at least find accurate reading material to educate yourself so that you're not just Googling in the ether.
Right. And I'd add that oftentimes this is a teamwork, right? It starts, the documents start with an attorney, but then if you never fund your trust, or if you never really implement what you agreed to do in your estate plan, then it kind of defeats the purpose. So make sure once you meet with an attorney, then you follow up with your financial advisor or the appropriate professional to make sure that everything falls into place and you actually fund the right accounts and change your beneficiaries, et cetera, et cetera. So it is a team effort.
Absolutely.
So, well, great. Well, I can't thank you enough, Jennifer, for your time. This was hugely helpful. Not the most fun topic ever, but definitely relevant. So thanks for hanging in there, everyone, and we hope to see you on our next coffee and conversation. Have a wonderful Thursday.
Thanks, guys.